Der erste völkerstrafrechtliche Prozess in Nürnberg vor dem Internationalen Militärgerichtshof stellt einen Durchbruch in diplomatischer wie rechtsgeschichtlicher Hinsicht dar. Für den Prozess wurde in dem zugrunde liegenden Staatenvertrag, dem Londoner Statut, Recht geschaffen. Mit Verbrechen gegen den Frieden und Verbrechen gegen die Menschlichkeit hat das Verfahren seinerzeit ganz massiv rechtsschöpferisch gewirkt. Bis heute sind diese Verbrechen als völkerstrafrechtliche Verbrechen kodifiziert. Solche Innovationen sind essentiell für die Fortentwicklung des Völkerrechts, das wie das Nationalrecht allgemein nur reagieren kann, aber eben auch neue mediale Möglichkeiten nutzen kann. Mit dem Berkeley-Protokoll soll dies angeregt werden. Es ist dementsprechend folgerichtig, aus Nürnberg, die Wiege des modernen Völkerstrafrechts, diese Innovation auch vorzustellen. Ich grüße die Teilnehmerinnen und die Teilnehmer der digitalen Konferenz, speziell der University of California, Berkeley und dessen Human Rights Center und der Friedrich-Alexander-Universität. Ja, meine Damen und Herren, als Oberbürgermeister einer Stadt, die sich in besonderem Maße der Menschenrechtsarbeit verpflichtet fühlt, ist es mir eine sehr große Freude und Ehre, an die Hohe Kommissarin für Menschenrechte der Vereinten Nationen, Michelle Bachelet, übergeben zu dürfen. Ich wünsche dieser Konferenz viel Erfolg, eine große Teilnehmerzahl und natürlich auch eine große Resonanz. Dankeschön.
It is an honor to take part in such an important event, both historic and forward-looking. Technology can help us see the distant, the obscure, and the unimaginable, and serve as concrete proof of violation of human rights and international law. And as technology advances, many new ways to harness these tools to protect and advance human rights are being developed. Cell phones, satellite imagery, social media, big data analysis, and many other digital tools have opened new channels for documenting attacks against civilians, their displacement, and destruction of civilian objects. These tools provide us with a new wealth of data and imagery, alongside our traditional on-the-ground human rights investigations, and help us to speak out against violations with greater confidence and certainty. So, how do we ensure that digital information serves as credible and reliable support to our work? How best can we maximize its utility for human rights accountability? This is a challenge that the UN Human Rights Office has embraced for some years now, as we undertake or support a range of investigations, including commissions of inquiry, special rapporteurs, fact-finding missions, and others. These forms of investigation often examine in detail situations involving the most heinous acts humans can perpetrate against each other. Digital imagery has been increasingly helping investigators verify what happened, where and when, as well as who were the victims and who may be responsible. I would stress that digital materials are subject to the same methodological rigor developed by my office regarding source assessment and protection, corroboration, verification, analysis, and standard of proof as any other method. They supplement and enhance our traditional techniques of inquiry rather than replacing them. Our aim is to ensure that international investigative standards are not overlooked in the speed of technological changes, and that new technology serves to strengthen the compilation of the evidence base and its analysis while boosting the credibility of conclusions reached. And indeed, digital data and imagery have supported outcomes of investigations in diverse areas. These have included torture, summary executions, enforced disappearances, sexual and gender-based violence, arbitrary detention, and other human rights violations even amounting to war crimes and crimes against humanity. And the examples are many. To cite just a few. In Myanmar, the fact-finding mission used satellite imagery to corroborate the account of victims, ultimately leading to a finding of crimes against humanity and possibly even genocide. A closely watched interstate case on these issues is now being adjudicated at the International Court of Justice. In Syria, our office closely examined the evidence of numerous videos, many released by the perpetrators themselves, showing captives being paraded in cages on the back of pickup trucks and the graphic executions of others perpetrated by adults and even children. Satellite imagery also assisted the Commission for Human Rights in South Sudan to find that crimes against humanity had likely occurred given widespread destruction of private property and attacks against the civilian population in over 40 villages over the course of 2 months. The work illustrated by these examples are why we have chosen to publish this protocol jointly with the Berkeley Human Rights Center. In addition to the development of this protocol, our office has been working closely with the Berkeley Human Rights Investigation Lab to bring verified digital information into United Nations human rights monitoring and investigations, including situations where our investigators have been denied physical access. Colleagues, this protocol has been developed by a diverse group of experts with diverse professional perspectives, legal and cultural backgrounds, and was subjected to a rigorous process of review, revision, confirmation, and validation. The protocol places protection and security at the forefront for, as we know, sources, human rights defenders, journalists, victims, witnesses, and others often risk their lives to secure digital information about violations. The direct evidence of victims and witnesses will always be primary evidence for us, and we must do everything to maintain their full confidence. In an era of widespread misinformation and disinformation, the protocol gains even more importance. It sets out principles and methods behind verification and authentication analysis that practitioners and lay people can comprehend, and identifies necessary core technical resources and technical expertise. And foremost, the protocol insists that investigators and others carrying out this work continue to be grounded in and bound by fundamental ethical, professional, methodological, and legal principles and standards. These principles ensure that the information is collected in line with human rights standards and therefore relevant and best usable later for wider accountability purposes when conditions allow. And that is the case whether material is presented in court, presented as evidence, in a vetting process or a transitional justice mechanism, in a commission of inquiry or fact-finding mission, or in any entity that makes determination as to the existence or not of a violation of international law. The protocol is ultimately about protecting human rights and advancing justice. In this regard, I welcome in particular its principles of humility, inclusivity, and dignity. We are now taking the necessary steps to ensure implementation of the protocol in our own investigation and those we support. I encourage others to do the same in their own areas of work. Thank you for joining us in continuing to stand up for the human rights of persons everywhere with all the tools we have.
Hi, I'm Alexa Koenig, the Executive Director for the Human Rights Center at Berkeley Law. After greetings from both Nuremberg and from Geneva, it's now my deep honor to welcome all of you to California's San Francisco Bay Area, the birthplace of the United Nations, a hub for technological innovation, and the home of the Human Rights Center. While I'm really disappointed that we're not all actually able to be in the same physical space together today, something we'd very much hoped for, I'm very grateful that technology has allowed us to at least come together virtually. And I want to thank you all for joining as we celebrate and acknowledge this historic moment, the 75th anniversary of the use of film as evidence at Nuremberg and the launch of the Berkeley Protocol on digital open source investigations, as well as the growing use of digital technologies to strengthen legal cases with online open source information, the videos and the photographs that people are posting to social media from all over the world who hope to share what they and their families have experienced or experiencing in the quest for justice. Unlike the films at Nuremberg, the videos that are being posted to YouTube and elsewhere online are digital. but they're no less powerful in their ability to let us know what's happening around the world and alerting the world to atrocities. Today, we'll hear from historians, practitioners, lawyers, human rights leaders as to how technology is helping human beings advance justice and how practice and protocols have contributed ever increasing legitimacy to the use of online information in the quest for accountability. Our first panel will look to the past to help us make sense of the present, both in terms of the use of film as evidence, but also the use of other innovations, including the development of protocols and their role in practice. Our second panel will bring us from the present to the future with an overview of where we've landed and what, in terms of technology and courtrooms, comes next. Afterwards, we'd love for you to join us for a toast and casual conversation. But mostly, I want to thank every single one of you. Everyone on this call today, and there are hundreds that have joined from around the world, has contributed either directly or indirectly to the protocol and to this moment. I'm grateful that we can collectively take the rare opportunity to reflect as a community on where we've been and where we're headed next. With that, I'd like to now turn to the moderator for our first panel, Dr. Katrine Kinzelbach. Dr. Kinzelbach has a professorship in international politics of human rights at FAU, where she also co-directs FAU's Human Rights Master's Program. Thank you.
Well, thank you very much. And it's a great honor to be with all of you today. We were hoping to host this event in Courtroom 600, and now we have come to a virtual meeting space. It is my great pleasure to moderate the first panel, and I will dive right into it. As was already mentioned, it serves to connect the past with the present. And you all saw the images of Courtroom 600 in the Nuremberg Palace of Justice just a few moments ago. This is where the Nuremberg trials took place. This is where legal and world history was written. And I invite you for this first panel to think back to those images and come to that space, at least virtually, and think with us about what happened 75 years ago in Nuremberg and the legacy of those historic events today. The first speaker on this panel is my colleague, Professor Christoph Safferling, who holds the chair for criminal law, criminal procedure, international criminal law, and public international law here at FAU Erlangen-Nuremberg. Most importantly for us today, Professor Safferling is a well-known expert on the Nuremberg trials, and he's also engaged in various roles with keeping the legal history of these trials alive. Christoph, the floor is yours.
Thank you so much, Katrin, for this kind introduction, and welcome to all of you. I'm very excited to be here. Thanks to Alexa for organizing this conference, this virtual meeting. I'm happy to speak about, in 6 minutes that I was given, on the legal history perspective on the influence of the Nuremberg trials. Well, of course, you all know, I take it for granted, that from a substantive law perspective, obviously the Nuremberg trials sort of created or executed for the first time these crimes, which were called the crime against peace, crimes against humanity, and war crimes. So you all know this, and I'm not going to talk about this. I rather want to focus on a procedure, because procedural questions, as it seems, are even today sometimes more important than substantive law. And we see also at the work of the ICC today that procedure is often critical and often discussed and poses questions and seldom and sometimes the answers are hard to find. Well, when you look at the Nuremberg trials from a procedural perspective, obviously that was a mega trial, as you would call it today. You had 22 accused. The trial started on 20th of November 1945, and it lasted until the 1st of October 1946. So in about 11 months, an end of this trial was found, obviously, at enormous speed. The trial was, for the trial, a new procedural system was created. It was based and well sort of fundamented in the Anglo-American tradition, with notwithstanding some new forms that were integrated. When I spoke to one of the prosecutors, Whitney Harris, who has died about 10 years ago, but I had the opportunity to speak to him. He always was very proud. He was with the Jackson team. He was always very proud that the procedure in Nuremberg was not only an Anglo-American procedure, but it tried to integrate some forms and some aspects of the German criminal procedural system. And he always pointed to the fact that the accused were given the last word. That's indeed a German traditional sort of right of the accused to be the last one to speak in a courtroom before then the judgment is handed down. Most of the German accused in the Nuremberg trial actually did make use of that and spoke their last word. But mind you, of the chief prosecutors, only the Russian prosecutor was present on 31st of August in 1946. No other chief prosecutor heard these last words. Well, but the procedural order was actually based on a first draft that was, mind you, prepared in San Francisco. But it was discussed in London in the summer of '45. And you had these cultures coming together. You had on the one hand, the United Kingdom, on the other hand, the United States of America. But you also had France and Russia, and of course also Germany, that came from a European culture, a continental European culture. Let me quickly come up with 3 topics that I want to focus a little in greater detail. First of all, one of the great achievements with regard to fairness, which is the overall perspective, the overall importance of this trial to be acceptable to the accused and to the victims. One of the first tools that was actually implied in the Nuremberg trial was the question of the fitness to stand trial. And you had actually 2 incidents where that was raised. The case against Gustav Krupp von Halbach was discontinued due to the age and the health condition of this German industrialist, to simply charge his son and bring him instead into the Nuremberg main tribunal was not allowed by the tribunal. And he was, of course, later charged in one of the follow-up trials. And then, of course, the case against Rudolf Hess, who almost was granted to leave the trial for his claim of amnesia, but that obviously didn't come true because he himself stated that he was fit to stand trial. Then, of course, the second point is disclosure of evidence. And everybody who knows a little bit about international criminal law in the ICC today in The Hague knows that disclosure is one of the main issues. And indeed, it was such an issue also already at the IMT. It was a discussion about whether the prosecution was forced to disclose also exculpatory material. And indeed, the tribunal made the prosecution disclose such material, which wasn't the case in the US. The Brady material was only later accepted by the US Supreme Court to be within the obligation of the IMT, of the prosecution to disclose it to the defense. And we always had a discussion at the IMT also about the amount of material that was produced and that the defense needed to get access to it. And there was a Defendants Information Center in room 45 of the Palace of Justice, where the documents were handed in the English translation to the defense counsel, but it was always an issue. And in particular, as it seemed that the prosecution was more ready to give the copies, to hand out copies to the press rather than to the defense counsel. And I can quote a little word from the president, which he said to Colonel Story, who was amongst the prosecutors in the US team. He said, "You don't seem to understand what I'm putting to you, which is this, that if you can afford to give 250 copies of the documents in English to the press, you can afford to give more than 5 copies to the defendant's counsel, 1 each. While we do not need to discuss it further, in the future that will be done." Of course, you see that the tribunal, in that case, the president of the tribunal, was very much aware of the fairness issues that were involved here. A third point that I want to make very quickly is the issue of cross-examination. Obviously, cross-examination, as Wigmore called it, is the greatest engine ever invented for the discovery of the truth. Well, for the Anglo-American tradition it is, not for the continental European tradition. And you had the cross-examination in the Charter in Article 24G of the IMT statute, but the continental lawyers were not really up to it. The German Defense Council did actually quite a good job, but some of the prosecutors, in particular Rudenko, as the Russian prosecutor, failed entirely when he cross-examined Hans Fritzsche, so that Jackson later advised not to let Russian and French prosecutors cross-examine. What I want to say, wrapping it up, what you see from Nuremberg, what we can learn maybe from Nuremberg for today, they had the courage and also sort of the competences to discuss the legal issues, the procedural issues on the spot, and have them decided on the spot. I mean, sometimes you wonder, because the arguments don't really get better if you sit down for 2 weeks or 3 weeks and write a long memo, and then the other side gets the opportunity to again recounter the memo. The parties can live with it if they are given a limited amount of time to forward an argument and then just decide and go on with it. Bring the case forward, and maybe even, as was the case in Nuremberg, if time is pressing, sit down on a Saturday and decide these procedural issues. A balanced way of an independent judge to direct the parties is tantamount, but this will always be accepted even for defense counsels and prosecutors today. Thank you very much.
Thank you very much, Christoph. This was fascinating detail, and I think also some new information there on procedural issues. And of course, you spoke already now about evidence, which is going to be a topic of more discussion now. As we move along with this panel, our next topic will in fact be the role of visual evidence during the Nuremberg trials. 1 week after the trial of the major war criminals began, so pretty much exactly 75 years ago, I think it was on the 29th of November 1945, the prosecution introduced an hour-long film entitled The Nazi Concentration Camps. And our next speaker is Axel Fischer, who works for the Memoriam Nuremberg Trials, which is an information and documentation center that includes Courtroom 600. So he knows that room very well. And that is also part of the public museums of the city of Nuremberg. Axel Fischer will tell us how the introduction of film came about 75 years ago and how that film material impacted the trial of the major war criminals. We look forward to hearing your insights. Axel.
Thank you very much, Professor Kinzelbach. Thank you for inviting me today, and a very big thank you to the organizers and to those that are responsible behind the scene who made this all possible. So I try to stick to this time schedule, and I'm going right into the International Military Tribunal in Nuremberg was a driver of innovation, but not only in respect to the creation of new crimes within the international criminal law. Nuremberg actually was the birthplace of simultaneous interpreting, and only because IBM developed, or if you will, invented the technical requirements, something what we would call conference technology today, the trial could be conducted in a reasonable way. The presentation of evidences also had been paid major attention to. If you look at the Nuremberg courtroom, you will recognize that in the center of the courtroom, there was the evidence. And one way of presenting these evidences was the medium film. The IMT trial in Nuremberg was not only extensively represented by photo and film recording, actually some 35 hours were produced, news was reported from it, and there were 2 documentary films produced, but the trial itself was conducted by the screening of a total of 6 films that represented the crimes tried before the tribunal. 3 films by the US, 2 films by the Soviet, and another one by the French element. Those taking the lead in this film program before the IMT were the US, after they had already developed a system for this. The motivation for filming war crimes or the scenes of such crimes becomes very clear by the following letter, and I want you to present slide number 1 now. This is a letter from General George Marshall to his superior, Dwight D. Eisenhower. Slide 2, please. This is the relevant passage. I will read it to you. On a recent tour of the forward areas in 1st and 3rd Armies, I stopped momentarily at the salt mines to take a look at the German treasure. There is a lot of it, but the most interesting, also horrible sight that I encountered during the trip was a visit to a German internment camp near Gotha. He's actually speaking of the Camp Ohrdruf, which is part of the film. The things I saw beg a description. While I was touring the camp, I encountered 3 men who had been inmates and by one rouse or another had made their escape. I interviewed them through an interpreter. The visual evidence and the verbal testimony of starvation, cruelty, and bestiality were so overpowering as to leave me a bit sick. In one room where they were piled up 20 or 30 men naked, killed by starvation, George Patton, another general, would not even enter. He said he would get sick if he did so. I made the visit deliberately in order to be in position to give, underline, first-hand evidence of these things if ever in the future there develops a tendency to charge these allegations merely to propaganda. End of slide, please. The next letter, the chief of the Nuremberg Prosecution Authority, Jackson's direction for a comprehensive film project to support the prosecution was handed on to the relevant places. This then resulted in the production of 2 films. End of this slide. The films were Nazi concentration camps and the Nazi plan. The first one about 70 minutes and the second about 3 hours long. The first is the famous one with the film shots taken in several concentration camps. The newness was the fact that these films were not like film pieces from a surveillance camera, but edited films. Elaborately cutted with a voice-over commentary structured in acts or chapters, comprehensible without additional explanations. What made certain film sequences and the edited films a piece of evidence? The basis of the film evidence program were 3 operations. First, they were cataloging potential film sequences recorded by the US Army Signal Corps, name of the members and the recording unit, name of members and of the war crime investigation unit, dates, places, the story behind it, witnesses, potential perpetrators, and so on. Second, they were encoding these film sequences to a system to assign the situation to a crime category. And then third, written affidavits by the producers of these films and their superiors. Slide 4, please. The encoding system sought to take account of 2 important categories. Crimes should be categorized first according to criteria given by the customary international law, and second, they should fit in the very ambitious US prosecution strategy that the crimes tried before the IMT resulted from a plot to obtain world domination, and that those not part of the core of the conspirators joined on different levels of the hierarchy a common plan to support that plot. Yeah, you can end the slide. It would take a very detailed analysis of these films, and we don't have the time here, but both films very strikingly reflect the outline program. But how were the films assessed by their producers themselves? Well, before the production of these films even started, before the trial, I found a memorandum that says, I quote, "For the first time in the history of legal procedure and jurisdiction, it has become possible to present in sound and picture the significant events of an historical period. In the case of the present war crimes trial, the International Court is in the position to found examination of the responsibility and guilt of the Nazi leaders, their accomplices and organized followers on the basis of factual evidence presented in the form of documentary photographs and original speeches. End of quote. Quite optimistic. After the trial had started and after the first film was produced, and even after demanded improvements were made, Gordon Dean, the chief of the press relation office inside the prosecution authority, came to a negative verdict. He says, the film would still be illustrative rather than evidentiary. It contains some good admissions, but they are not sufficiently striking to warrant their use during the presentation of evidence. And I doubt seriously if there is anything in the film which the defendants themselves would deny if they had knowledge. So, did the films have an impact on the judgment? Well, if you look at the verdict, there is only one half sentence that mentions these films at all, and it says that certain crimes were also presented to the tribunal in cinematographic films. That's all, nothing more. But allow me some closing remarks to that issue. The whole trial was not only the search for the individual guilt of some 20 defendants, but it was also a gigantic undertaking to collect, systemize, and evaluate all kinds of records that documented the crime history of the National Socialist German Reich. And these films have created the absolute canon of the visual representation of the Nazi crimes. And I am convinced that these motion pictures, at least, did their job in impeding the attempt to downplay these crimes or even deny them. Thank you very much.
Thank you, Axel Fischer, for this information on how the films came about, and also we began to discuss the role that they played, both in terms of evidence and also in terms of the larger impact of the trial. It is now my great pleasure to introduce the third speaker, who might actually tell us also about her experience from behind the scenes and how maybe some information that doesn't maybe fully meet evidentiary standards can still influence the impact of trials. And the third speaker is Dr. Navi Pillay, who really needs no introduction. Dr. Pillay served as the UN's High Commissioner for Human Rights. She was a judge at the International Criminal Court in The Hague and also at the International Criminal Tribunal for Rwanda, and also a judge at the Supreme Court of South Africa following the end of apartheid. Dr. Pillay, you have decades of experience struggling for human rights and also adjudicating cases based on international criminal law. So as you look back at your distinguished career and the long trajectory of modern international criminal law since the Nuremberg trials in 1945, what is your perspective on the legacy of Nuremberg, and more specifically on the role that visual materials and new technologies more broadly have played in the struggle for justice?
Thank you, Katrin, for that introduction. And I'd like to begin by warmly congratulating Eric Stover, Lindsay Freeman, and Alexa Koenig for the protocol. I'm going to drop the big name. So I think it's a great event to have this protocol launch, and I'm happy to have played a minuscule role on the advisory committee that worked on this protocol. I'm also associated with all four supporting bodies, I'm very pleased to notice: the Berkeley Human Rights Center, Friedrich Alexander University, my former office, the Office of the High Commissioner for Human Rights, and the Nuremberg Principles Academy, on which I serve as president of the advisory council. But as you said, Katrin, when I reflect on the topic you've given me, the historic use of technologies to strengthen justice, I want to do so in the national context. From my experience as a defense lawyer fighting apartheid, and in the international context as one of the first judges on the ICTR, one of the first judges on the ICC. I mentioned the first because, you know, when you that's where you're on the crux of change and you can introduce new elements. So in these positions spanning 4 decades in courtrooms, I should say, I have lived and experienced the historic progression in the admission of digitally derived evidence and increased use of technology to serve the interests of justice. And courts are traditionally slow to change, and they often viewed technological evidence such as films and videos as inherently suspect because, I suppose, of concerns of authenticity, chain of custody, and preference for eyewitness testimony, and also just of their stubborn clinging to tradition. So I noticed what Axel Fisher has said about the comment from the bench on these films. Now, the major challenge for justice in the apartheid era was that state agents controlled all relevant information and defense counsel had no access to it. And an example would be the case of the murder by torture of the Black consciousness leader Stephen Biko, together with hundreds of other cases of the deaths of opponents of apartheid while in the custody of the secret police. So access to visual footage and digital information for victims, for defense lawyers, and the public was very limited. And I feel this is an important area we should focus on. How do they access this information from the control of sources such as governments, institutions, or domain owners? So we need that access for defense counsel and victims if we want to be serious about strengthening justice equitably. Now, of course, apartheid has ended, but regrettably, in many countries, there's still the practice by state authorities to withhold evidence, to deny access to information rather than making such access available to courtrooms. They do so on the grounds of state security or not in the interests of the state. Now, I'm surprised to hear that a directive was issued recently in a province in France forbidding the taking of photographs and videos of police during street protests. We all know that had it not been for video footage taken by the media and bystanders, including in the case of the killing of George Floyd in the USA, the world would not have woken up to police brutality. And you know, I was looking forward to seeing one of these films that Axel Fisher referred to, but I heard him say they were very long. But what people say is the impact of the visual imagery in bringing home to the court the horrors that were committed. Now, true, I'm going to address that as a judge who experienced the effect of visual imagery. So when, as one of the first 6 judges, I was elected to the ICTR in May 1995, and we took our seat in rural Arusha, Tanzania. I mean, there was no technological support, let alone telephones. We didn't have telephones, computers, or even power, regular power. But when I took my seat, I realized that trials of international crimes of genocide, crimes against humanity, and war crimes were not the same as presiding over the trial in a single murder in a national court. Because in a national court, you know, they almost produce the body with forensic evidence, medical evidence, you're able to establish the cause of death. Here, how do we listen to evidence of murder and find intent, apart from the regular witness testimony? When there's no medical evidence, they could be opportunistic deaths rather than serious injuries, for instance. How could we reach findings on widespread and systematic killings, which is an element of the crimes against humanity? The Rwandan government, in deference to their local customs, prohibited exhumation of graves. The tribunal judges had the benefit of testimony of survivors, but no single witness had seen the events that had occurred throughout the country. And no single witness or series of witnesses saw the killings of close to 800,000 Tutsi members of the population. Now, but fortunately, we were presented with visual imagery and other digital information, and I'm very happy to say we were first 6 new judges hearing international trials for the first time, and we saw the benefits of this. What were they? A doctor from Médecins Sans Frontières showed films he had recorded of the killings that were in progress as he and other doctors were fleeing. They were ordered to flee, of course. They were fleeing in their vehicle, and he held his camera through the window. He took all this footage of bodies and bodies. He filmed hospitals, mortuaries showing hundreds of corpses. Another is that we had the benefit of BBC and other channels who shared live footage of large-scale killings by attackers wielding machetes. Some of those fleeing were rendered immobile when their ankles were slashed to stop them from running, and the killers returned to finish the job of those fleeing. We saw films of men and women forced to kneel at roadblocks as the attackers, the Interahamwe, were bludgeoned them to death in a long, drawn-out process. So they would slash their heads, then stand around and smoke, return and do more of that, until at one point the presiding judge stopped the footage because we judges found it unbearable to watch the victims still in the throes of death. So true, visual imagery, but it made a profound impact on us. We saw film footage of bodies in the rushing river, and I will never forget images of beheaded corpses of babies and children in that rushing water, like one every 30 seconds. And of course, I see Eric Stover on our panel. I recall Eric Stover giving evidence at the ICTR in which he produced thousands of slides of excavated corpses. So all that was very useful. The digital evidence provided graphic support for the eyewitness testimony, but that evidence also gave us an understanding of the genocidal proportions of the crimes that had occurred. Now, in another important case in the ICTR, at first also, is the media case. Here, the allegations were that the broadcasts of the radio station RTLM had spread hateful propaganda against Tutsis and had called on the Hutus to kill all Tutsis. So this case is important because of the crime of when does hate speech become a crime, when does it become genocide? And we relied very heavily on the cases in Nuremberg because we had no other precedent under international law for such a case. Now, witnesses testified in the media case that the RTLM radio station spread hate speech like little drops of petrol that soon caught alight and set the whole country aflame. It was alleged that had it not been for these broadcasts, the genocide would not have engulfed the entire country, resulting in the death of close to 1 million people. Therefore, it was necessary for electronic records of the broadcast to be produced. So who had these tapes? We heard that the agents from the United States, I believe the FBI, were there while the genocide was going on, and they took custody of all these tapes. I heard from the then prosecutor Carla Del Ponte that she went to Washington and managed to access some of these tapes that were produced in court. Now, these new technologies certainly help the judges to connect the dots and make findings that hate speech spread by the media in question amounted to incitement to commit genocide. However, I remain concerned over these new and emerging challenges relating to access to digital information, which is necessary for the strengthening of justice. And my concern is that we are beholden to the sources that control that information. In the case mentioned, where FBI had custody of the material, defense justifiably complained before us that they had not had equal access to the material in the possession of the FBI, and that disclosure was selective and partisan. Obviously, the prosecutor picked what she thought was helpful to her case. Questions need to be addressed then on whether the ordinary rules of evidence safeguard the rights and roles of various stakeholders, those who control or own the information, and the rights of prosecution, defense, and victims. Since Nuremberg, since the ad hoc tribunals, we have progressed further into new technologies, to satellite images and high-resolution photography, complex phone communications and networks, computer-driven technology, closed-circuit television, drones, autonomous robotics to the electronic or social media, and direct access to almost live documenting or recording of atrocity crimes. You know, there's so much, as we all know, that has happened in the technological area. I thought I will race through just those bits, not that I know of all of them. I had to consult my grandson to find out what's the newest now. So presently under lockdown, stemming from COVID-19 crisis, who would have thought that this would happen? Many countries are holding online trial proceedings. Once again, a new experience. So in conclusion, let me say without doubt, digital evidence and new technologies are advancing fast. It would be true to say that the past 30 years has seen more rapid growth in the international rule of law accountability mechanisms than at any time since the inception of the Nuremberg Tribunal. And the same can be said for the rapid growth in the use of digital evidence in the last decade or so. A question then that remains open is how fast are we advancing to address, one, rules governing digital evidence, two, standards developed and developing with respect to usage of digital evidence and new technologies, three, ethical considerations and codes governing the synergies between international criminal law and human rights, and four, the adaptation of digital evidence and rules of procedure within the courtroom in response to the imperatives of judicial proceedings. Thank you, Catherine.
Thank you, Navi Pillai. And I think you have so many insights to share that we could be listening to you for 7 hours and not only 7 minutes. So thank you for the tour de force that you have given us. And clearly we see a former judge here who is very open to integrating new technologies into decisions and also asking questions about access. And I think here we have, of course, a huge difference between the reality in 1945, also in terms of who produces those visual materials, and today, where hopefully we can speak more about that in the panel number 2. In light of the time, I need to already hand over to our final speaker, last but not least, joining us on this panel from across the Atlantic is the already mentioned Professor Eric Stover, who is faculty director of UC Berkeley's Human Rights Center and professor of law and public health. He has investigated war crimes and human rights abuses for more than 40 years in different parts of the world, including, of course, with forensic investigations. Now, before the next panel discusses the Berkeley Protocol in greater detail, Professor Stover will give us a brief overview into the history of such international protocols. How do they originate? How are they built? And what is their impact? Thank you very much for joining this panel. The floor is yours.
Thank you, Katrine, very much. So I have a slide presentation. Thank you, everyone. The reason I want to give a slide presentation is I do like to honor the survivors who we work with in our investigations. So this is a little provocative. I've titled it Bringing the Crime Scene into the Courtroom, but that's half the story. And the reason I put that's half the story is because I want to go back and I want us to focus on the role that investigators have played, and particularly in their interaction with the survivors of mass atrocities and what this means, because this is somewhat the hidden story, the story that's never often told. Next slide, please. So I'm going to talk about two principal protocols. There are very many protocols. There are handbooks that are produced on reproductive rights and also on documenting, investigating sexual violence and conflict. But the two protocols I'm going to focus on are ones that I participated in, and that's the Minnesota Protocol on potentially unlawful death, and also which was originally developed in 1991 by a group of lawyers at the University of Minnesota, hence the name. And I worked with a team of forensic scientists and the Argentine forensic anthropology team in producing this protocol. The second is the Istanbul Protocol, which looks at the medical legal investigation of torture. And this was pulled together by a group of physicians from around the world, other health professionals, often under the guidance of Physicians for Human Rights. I won't speak much about the Berkeley Protocol because we'll talk about that later. Next slide. So let's go back 75 years, and it's early in May 1945. Finally, the Allied powers have decided, they debated, there will be war crimes trials. And many of the Allied forces that were moving into Germany had intelligence corps, the United States did, but many of these intelligence officials who were coming in, who were going into the concentration camps, were not trained particularly in investigating these sorts of horrific crimes. Next slide. One of those was Corporal Ben Ferencz, and Corporal Ben Ferencz turned 100 years old last March, and he was in the Central Intelligence Corps and with the US Army, and he went into concentration camps and he was mandated to begin investigations. And I want to read a quote that he gave a few years ago about this. He said, "Entering a concentration camp very soon after it was liberated is entering hell. Total chaos. The troops and trucks are coming in. The SS guards are running out into the woods. The inmates are lying there. Some are dead or dying. And I've got to go in and seize all the records, take the testimony, go back to the headquarters, sit down and type up the report for what might become a war crimes trial. Now, the effect on me has been a difficult one, from which I suffer to this day, and that couldn't be concealed or overcome. I put it in a side drawer because there was a job to do, and I had no time to waste with emotion and sentiment. I had to get down and move on to the next camp." So we know Ben Ferencz went on to be a prosecutor at the age of 27 with the Nuremberg trials. Next slide, please. So now let's fast forward 40 years. We're in Argentina. The military government has finally left power, and there are thousands that disappeared. I took a forensic team down to Argentina to help train students who are archaeologists and medical students, and they began what has been monumental work over the last 35 years. This team has gone to more than 30 countries around the world and trained other teams. It was with this forensic team that we worked together to produce the Minnesota Protocol, which would set out how to conduct these investigations. Next slide, please. The Argentine team adopted a blueprint approach. And that was, they would go to Chile. In Chile, they trained a team. They went to Peru. They went to Guatemala. And in Guatemala, was formed the Guatemala Forensic Anthropology Team, which is now in over 30 years of operation. And these teams, by their work, we were able to integrate into the Minnesota Protocol the basic principles of how to conduct these investigations. Next slide, please. Moving to the Istanbul Protocol, what everyone needs to know, and I often, it bothers me when I read history books about human rights, that they often overlook the local organizations and what they did and demanded for justice back in the 1980s. And in particular, in many countries around the world, there were doctors and health professionals, nurses, and so on, who were working with torture victims. This is a doctor in South Africa. There were actually a number of South African doctors working under the radar who were treating torture victims. And I had the privilege in the early 80s to actually go and interview many of them. Next slide. Also in the Philippines, there was the Medical Action Group and doctors, again, who were examining and seeing torture victims. Next slide. And in Chile, there was quite a bit of actually doctors who had participated in torture, but again, many physicians, Michelle Bachelet herself as a physician, worked with an organization aiding children of torture victims. But there in Chile, there were doctors who were also treating torture victims. And what needs to be understood here is what these doctors were doing was highly dangerous work, and often they were detained. And they were doing this simply under the radar. But what they did is eventually came together to develop the Istanbul Protocol as a means of educating others about what would be the basic procedures that should be undertaken for a medical legal examination of torture victims. Next slide. So what do these protocols bring? First of all, an utmost importance is scientific and medical legal rigor. It is what we saw in the 1980s was the fact that now there was going to be physical evidence and trials and truth commissions that were going to be presented, and it had to be very scientific and medically, legally acceptable to the courts. Next slide, please. Also admissibility. This is Dr. Clyde Snow, forensic anthropologist, probably presenting, I believe, probably the first time a forensic case in a large human rights trial. This was the trial of the military junta in Argentina. But admissibility, that evidence that is collected by these professionals is done in a way that it is analyzed, preserved, and held to chain of custody so it can be presented in court. Next slide. And this is where I really want to shift to the other half of the story that's often not told. And that is with these teams in Guatemala and Argentina and the physicians who work, it's for us to understand what emotional as it was for Ben Ferenc's task it is. And what they try to do is, of course, follow the ethics of knowing that they're working in communities, that they interact with those communities. And here is a picture of a exhumation that's taking place in Guatemala. The forensic team there is very good at working with families and villagers. They'll set up sites so they can, as you can see here, come and watch what they're doing and be able to say prayers as they wish. Next slide, please. And to wrap up, it's all coming down to justice and accountability. And what I want to just end on and emphasize is that we need to understand and honor the investigators because they're the ones in the field. They're doing this year after year. It can be very traumatic work. And also to recognize the survivors and the fact that the survivors work with the investigators, and for them to see justice is an opportunity for them to have their day in court as well, along with the evidence. Thank you.
Thank you, Eric. We would have now a lot to discuss on this panel, but I hope the next panel will be able to pick on some of the themes that the various speakers have given on admissibility, on issues of evidentiary standards, of honoring the survivors who today are often also the investigators, or at least the documenters of the crimes experienced by them. And maybe the new technologies give them slightly more power today than they still had in 1945. So hopefully the next panel can pick up some of these points. I would hand over rather directly to the moderator of the second panel, which will be Dr. Alexa König, who already spoke in the beginning, and I think some of the people in the audience joined later. You are, of course, one of the driving forces behind the Berkeley Protocol and a pioneer of digital human rights investigations. I don't think in this space you need any introduction, so I will just hand over to you, Alexa.
Thank you, Katrine, and thank you to all of our amazing speakers and for the foundation that you've laid upon much of what we're going to be talking about next has been built. This next panel will be talking about where we are now and where we're headed next with the use of visual imagery and online open source information for justice and accountability, as well as a little bit more about the Berkeley Protocol itself, what it contains, how it came about, and what we're hoping it might accomplish. Of course, no protocol can ever be effective without broad implementation. And therefore, we'll also be hearing about how the technologies and methods that gave rise to the protocol are playing out in practice and the additional tools that are being developed to help strengthen this for the future. For the sake of time, I would love to move now to our first speaker and to welcome Kelly Matheson, Associate Director of Programs at the NGO Witness. She leads their Video as Evidence project, ensuring that frontline documenters have the information they need to maximize the chances for the footage they capture to hold human rights violators to account. With that, I would love to turn the floor over to Kelly. Thanks.
Thank you so much, Alexa. And first, it's a great honor to be here with all of you tonight. Thank you so much for having me. As we heard during the first panel, the foresight to present film footage as evidence, and also actually to film the Nuremberg trials opening up Courtroom 600 to the world broke uncharted legal ground. It also forms the cornerstone upon which we are developing good practices to leverage visual and open source evidence in justice processes today. But before we celebrate just a handful of the landmark evidentiary uses of visual and open source information along the path from Nuremberg to 2020, I really want to underline that just as in the Nuremberg trials, damning visual evidence will never do away with the need for other evidence, such as documents, physical evidence, or witness testimony. However, with that emphasized, visual and other open source materials today, more than ever before, can and do serve as powerful direct evidence. They prove criminal acts. They are used to prove the intent of the perpetrator. These materials, these evidentiary materials, are used to prove the role of that the accused played in the commission of the crime, or even to exonerate those that are falsely accused. So let's have a look at some of these great stories from the field, with a note of caution for everyone that what I'm about to talk about and show includes difficult human rights contents. So Alexia, if you could bring up the PowerPoint, that would be great. Okay, so back in the early 1980s, many of you will know a young filmmaker named Pamela Yates. She captured then dictator General Reyes Montt bragging about the control he had over the forces. Let's watch this short 20-second clip.
El valor nuestro está en esa capacidad de poder responder a las acciones de mando. Eso es lo más importante. El ejército está en capacidad de reaccionar, porque si yo no puedo controlar al ejército, entonces, ¿qué estoy haciendo aquí?
So this footage of his admission, together with other parts of the interview, served as direct evidence to help prove that Montt had effective command over the troops carrying out genocide against Guatemala's indigenous peoples. While this case was later dismissed on procedural grounds, substantively, the court's guilty verdict of genocide still stands today. So we're going to move to slide 2, and we're going to move to Mali, where journalists from a variety of media outlets working on the ground in 2012 captured irrefutable evidence of Ahmad al-Faqi al-Mahdi planning to and destroying historic religious sites. Again, let's watch.
Here, the prosecution showed footage of al-Mahdi taking part in a meeting to plan destructions. The prosecution also showed footage of al-Mahdi himself participating in and even supervising the destruction of religious and historic buildings.
These journalists collected hours of video footage, including on-camera interviews where al-Mahdi clearly states his intent to commit these crimes. This visual evidence and much more helped the International Criminal Court to secure a guilty plea for war crimes against al-Mahdi. So now we're going to move to the next slide into 2014, when an insider working as a forensic photographer for the Syrian regime, who goes by the pseudonym Caesar, shared over 50,000 damning images taken inside of Syria's prisons. These photos showed the corpses of numerous prisoners that had been tortured and killed in detention centers. The former US Ambassador for War Crimes, Stephen Rapp, described this collection of photos as the clearest case he's ever seen of international crimes. Now, while this collection of Caesar photos have not yet realized their full evidentiary potential, criminal actions have been brought against members of the regime in 6 European jurisdictions to date, with more to come. These photos are poised to be used as crime-based evidence, contextual evidence, and linkage evidence in these cases. So next, let's go to the next slide and go to Yemen, and where less known crimes are happening. There was one September morning, an airstrike, one of many, hit a pickup truck and killed 3 women and 12 children on their way to harvest vegetables in the fields. The human rights NGO, Mawatana, collected photos of the truck, the crater, and the munitions at the scene of the strike. Jihad, which is a Saudi-led Arab coalition formed to investigate allegations of civilian harm, concluded that this attack was on military commanders in a military vehicle, not on civilians. Mawatana's photographic evidence will help refute Jihad's false findings. And finally, let's move to the next slide and to Nigeria. So while we are here honoring the Nuremberg prosecutors, in Nigeria, right now, there's a network of 800 volunteer lawyers with End SARS Legal Aid that are tirelessly sifting through video that was filmed and posted on social media by protesters and bystanders. The lawyers are then taking this open source video evidence to the authorities to exonerate protesters that have been falsely accused of crimes and imprisoned by Nigeria's Special Anti-Robbery Squad. To date, this legal aid group has freed 337 innocent protesters. So we can leave the slides now. And while these are just a few of the many stories illustrating how visual and open source evidence are being used in pursuit of justice, there are so many more to come. And while I recognize that there are numerous challenges in using these types of evidence, I do not doubt that in 25 years from now, when we are honoring the 100th anniversary of the Nuremberg trials, there's going to be a new generation of lawyers that are leveraging open source visual evidence from filmmakers, from journalists, insiders, NGOs, peaceful protesters, and as Michelle Bachelet highlighted, from perpetrators as well, as the core evidence in most, if not all of their cases, in hopes that this leveraging of evidence will support the long arc of history as it bends us towards justice. So with that, a very special thanks to all of you who came before us, and to those that are yet to come. We owe a debt of gratitude. So thank you very much.
Thank you, Kelly. And I think we also owe a debt of gratitude to you and to Witness for your pioneering work in really thinking through creatively and constructively how we can better leverage video to help achieve justice in courtrooms. So thank you again. And for also helping to pull together this event today. I know you had mentioned that it's the 75th anniversary of the use of film as evidence in an international courtroom. It seemed like a perfect moment to bring together a community to talk about what comes next. I also want to thank Mr. Paul Seals for joining us today. Mr. Seals is a member of the United Nations Fact-Finding Mission for Venezuela and Director of Peace Practice and Innovation at the European Institute of Peace. He will talk now about how the United Nations has been using user-generated content in their documentation of human rights violations. Mr. Seals, the floor is yours.
Thanks very much indeed. Very happy to join you for this celebration and the launch of the protocol. It's, I think, an important and very valuable instrument, and I think that's shown in the context of the trajectory of the work that's been going on for decades. It's already been presented in the preceding panel. I'm going to speak very briefly on the experience of the Venezuela fact-finding mission and its use of video evidence. We'll look at two videos that we used to different degrees to help establish the facts and the relevant incidents that they deal with. I should warn you that they are both to some extent violent, and the second one is particularly violent, showing a fatal shooting. So please be warned of that before you see it. Before going to the first video, I should explain for a moment the resources that we had available in using the video evidence, which were fairly limited in some senses, but extremely useful nonetheless. We had one full-time digital forensic investigator, Francisco Nunes, and he was his role was essentially to analyze the videos that we were interested in, check the metadata where it existed, verify the authenticity of the videos, make sure, for example, they hadn't been doctored or tampered with in any way. He was also responsible for the important work of accurately storing the data, something that I'm sure others will speak to as a very important role. And he worked on the development of the standard operating procedure with the digital verification core with Sam Dubberley and his people, who helped essentially go through huge amounts of videos, either at our request, the investigators' request, or through their own scouring effectively of open source videos that existed. So it depended in different ways how they went there. So those were the resources we had, along with our own experts and the investigators working together to analyze and assess these videos. Perhaps if we can show the first video now, and I'll speak to that for a moment or two. The first video itself, as you can tell, probably looking at it, is not hugely informative. It was difficult to locate. It wasn't easy to tell from the narrow footage, if you like, exactly where it was, etc., from the video itself. But by contacting witnesses, we were able to verify its location in a demonstration in Caracas. What we know now was that it was taken moments before the fatal shooting of the gentleman you see in the foreground, a man called Armando Cañizales, an 18-year-old. He was shot moments after that, and we were able to verify the circumstances of his shooting. The video itself does not give us a huge amount in proving a number of issues there. One of the contentions of the government was that he had been shot by people behind him, people in the protest and the demonstration itself. The autopsy shows that he was shot in the front, i.e. facing whoever shot the gun at him. And the relevant evidence that we assessed from others showed that the balance of the evidence showed that he was in fact facing the policemen and soldiers who were monitoring and patrolling the demonstration. So a limited amount of evidence coming out of that in terms of what we could use to verify the facts. It gives a little bit of context, but not in any sense a definitive version of the events, and certainly doesn't capture the shooting. If we can go to the second video, please. I should say before it's shown, again, this does show a fatal incident here at the beginning, and it's very much in the first 4 or 5 seconds that the key events take place. As you see, someone's throwing something over this.
imágenes en la Plaza Francia del Tamil, algunos decían que no iban a bajar hacia la autopista. Otras personas, pues por el contrario, dijeron que se iban a bajar. Vemos que continúan. Ustedes están viendo, los funcionarios de la Guardia Nacional continúan en este caso disparando en contra de los manifestantes. A esta hora directamente en la Ropa ha comenzado pues, el lanzamiento pareciera por el sonido. Y lo decimos así porque tampoco vemos el humo de los gases lacrimógenos que emanan normalmente.
Thanks very much indeed. What the second video shows is actually far more conclusive to compare it to the first. It was very easy for us to locate what was happening. It was filmed outside a prominent, easily recognizable military base in central Caracas called La Carlota. It's identifiable because of the fence and the various other things that are there. The video shows very clearly a member of the security forces shoot a man almost at point blank range through the fence. If you notice right at the beginning of the video, in the first 3 or 4 seconds of it, there's a man at the front and he appears to be throwing something over the fence, some kind of object. It's not clear from the video what it was, but it was very close to the soldiers or to the armed men in the pictures. Our view was that given the proximity, how close he was to that, and the fact is that we know also that it was possible, given the nature of the fence, for the people to see what it was, that the person who was shot, who's called David Valinillas, was actually shot with a 12-gauge shotgun, almost at point blank range, as you can see through the fence. The autopsy, shows how close that was, the nature of the wounds. He was able to survive for a very short time, but died very, very, very shortly afterwards, being shot. The video allowed us to, in the fact-finding mission, to strengthen the findings that we had. We could see the context of it, we could see the proximity, we could see the use of force, we could see what the soldiers were able to judge in the context of the demonstration. And we were able to make our conclusions that in those circumstances, we believed that that amounted not just to an arbitrary deprivation of life, but indeed to an execution. And given the opportunities that were there to the soldiers and given the nature of the incident itself, that effectively demonstrates to some extent the challenges that we had. As it can be seen, sometimes the videos help you at least to contextualize and get a sense of what was going on in the incident. Other times you can get much more graphic information that goes beyond context and captures the actual shooting, as we have in the second incident there. And it allows you to see very clearly the nature and the relative, to some degree at least, the relative risks and opportunities that were faced by the authorities, the armed authorities facing the demonstrators, and whether or not what they did was in any sense reasonable in particular circumstances. The use of that, obviously we could verify the video, verify and locate where it was taking place. As I say, I think the two videos themselves show the difference and the kinds of opportunities and advantages that you have. They enhance and corroborate to a large degree the video, the eyewitness testimonies that are obviously brought to these events by the people who attended and who survived them, but it also gives, I think, a degree of objectivity and clarity, and I think strongly enhanced the findings in that particular case. I won't go further at the moment. I think that demonstrates two cases where we were able to use videos, one to great effect and one to much lesser effect. Thank you.
Thank you for your comments and the important work of your team, as well as these examples, which I do think are such powerful illustrations of how video can be integrated into fact-finding with the idea of building a public record. I was also struck by the mention of the Digital Verification Corps led by Sam Dubberly at Amnesty International. I think one of the really exciting ways that this field is growing is in these new collaborations and partnerships where people with very different skill sets can come together in this quest to strengthen justice more generally. I do think the legal field owes a debt of gratitude to the journalists and to the human rights advocates who've really been pioneering a lot of the methods that we're now trying to bring into legal practice. And of course, to the lawyers who are thinking critically and constructively about how we do so in ways that ensure we uphold due process in the rule of law. With that, I want to thank you again so much. And now welcome Ms. Lindsay Freeman, who is Director of Law and Policy for the Technology Program at our Human Rights Center at UC Berkeley. A special thanks to her as well for the hundreds of hours she's invested into the protocol over the past 3 years, including keeping this project on track and helping to pull together this community of practice that we have now on our call today. Thank you, Lindsay.
Thank you. 75 years ago, one of my legal heroes, Justice Robert Jackson, stood in courtroom 600 and explained that the judges need not rely on the potentially biased testimony of the defendant's adversaries because every count in the indictment could be proved by books and records. So that the proceedings would not be simply dismissed as victor's justice, the prosecutor argued that the Nazis be convicted by their own meticulously kept records, their own photographs, and their own film, through which all could hear their voices and see their criminal conduct replayed on the big screen. The fact is that publicly available information on the internet today is not all that different in substance than the documentary evidence that laid the foundation for the world's first international criminal trial. From Venezuela to Myanmar to Libya, we hear the voices and see the conduct of perpetrators all across the world on our small portable screens. Many parallels can be drawn from Nuremberg to present day, but there are also noteworthy differences, perhaps the most pronounced of which is the increasing difficulty we as a society face in sorting out the real from the fake, a problem that is certain to worsen with the increased use of artificial intelligence. Unlike with film, one cannot assume that a digital video is an accurate representation of events. Digital material is volatile, fragile, and easily manipulated. The internet is a dynamic and complex information environment where traditional social contracts do not exist, where primary sources are often unidentifiable, and compelling content may be impossible to verify. The democratization of technology has opened up exciting opportunities for investigators, but has also raised challenging questions about the ethics, security, legality, and methodological soundness of new investigation techniques. This dilemma is precisely what led the UC Berkeley Human Rights Center and the UN Office of the High Commissioner for Human Rights to develop international standards for handling open source digital information. The Berkeley Protocol on Digital Open Source Investigations addresses these evidentiary challenges by providing a framework for how to think about, use, and judge investigation methods that exploit new technologies. It includes definitions and ethical principles, chapters on security and relevant laws, explanations on what to do and what to document at each stage of the investigation cycle, from identification, collection, and preservation to verification, analysis, and reporting, and includes several annexes with a glossary and templates for digital risk assessments, digital landscape assessments, and online investigation planning. It deals with both the complexities that arise when dealing with online sources and verifying digital content, with the goal of maximizing its use in the widest range of jurisdictions. The protocol serves to teach investigators how to efficiently harness the power of the internet to advance their cases, and provides judges with the baseline knowledge necessary to ensure proper safeguards are in place, while at the same time appreciating the relevance and probative value of this type of evidence. While seeking to standardize procedures across disparate investigations, institutions, and jurisdictions, the guidelines remain flexible enough to adapt to context-specific needs. The protocol was developed through a series of consultations and interviews with a diverse range of practitioners from various disciplines, as well as through professional workshops and review by our editorial community and other experts. In later stages, we workshop the material in our investigations lab and with external partners who tested early drafts for the efficacy and practicality of the guidelines. We are extremely grateful to the many, many people who contributed to this work, as you'll see from the very long list of names in the document. In addition to the many incredible people who were named in that document, there are also many people who made contributions who could not be named due to the sensitive nature of their work. These include law enforcement, military, and former intelligence officers, as well as investigators at international tribunals. Members of the Office of the Prosecutor of the International Criminal Court were indispensable to this process, as were the members of the High Commissioner's Office. In particular, tremendous thanks go to Vic Ullem and Jackie Zaukberg, whose thoughtful edits and brilliant collaboration made the text undeniably better. Finally, I want to thank my super supportive and endlessly inspiring colleagues at the UC Berkeley Human Rights Center and express my gratitude to Eric and Alexa for giving me the opportunity to work with you on this incredible project. Less than 8 months before Justice Jackson's opening statement at Nuremberg, the law had not been codified, no procedures had been established, no tribunal was in existence. Courtroom 600 was an enemy fortress in the hands of German SS troops, not a usable courtroom. Similarly, at the start of this project, there were no procedures, no standards, and only a nascent professional community doing this work for justice and accountability purposes. During the 3-year development process, this community of open source investigators has strengthened to meet the challenges and opportunities brought about by digital information sharing platforms. We took a first step in creating a framework that others can build upon as new types of digital evidence and technology-assisted investigation methods arise. Following the groundbreaking example set by the Nuremberg trial, we hope that the Berkeley Protocol will be part of a greater movement to create standards that advance international human rights, justice, and accountability by thinking towards the future and preparing for the challenges ahead. Thank you.
Thank you, Lindsay. And after the final closing remarks, we will be going ahead and sharing the link to the protocol in the chat. You'll finally have a chance to have a copy for yourself and hopefully be able to start implementing it. I want to now thank our final and welcome our final panelist, Mr. Klaus Rockwitz, who is director of the International Nuremberg Principles Academy, who is spearheading an effort to ensure that legal practitioners have access to the broad array of resources they need to make digital content for justice and accountability, and to make that work as effective and as efficient as possible. Mr. Rockwitz.
Well, thank you very much, and let me join the others by thanking Katrin, you, and all the other organizers who make this event possible here. Just looking at the number of participants, Courtroom 600 would have never been able to host everyone, such a large community, and so that also shows what opportunities are generated by modern technology. I would like to pick up on what Lindsay has just finished, and that is the existence of the protocol now. This groundbreaking work that has been done that now is actually offering a tool to overcome the many, many difficulties that we observe, not only in the using of digital evidence, but in the using of every kind of evidence. I've hardly seen a document or rarely seen documents whose authenticity was not contested by the defense lawyers. I've not listened to witness testimonies that were not challenged as biased, as false, as wrong. And we will have the same, of course, with digital evidence and with open source evidence. When the International Criminal Court applied for the arrest warrants in the Darfur situation quite a while ago, it was clear that given the complete lack of cooperation from the government of Sudan at that time, years ago, made it impossible to conduct in situ investigations. So the evidence was largely compiled from witness testimony, witnesses that could be found outside the country, and open source material. But that open source material at that time was not digital evidence, it was newspaper reports largely. And there have been quite a number of comments in the legal in the academic press about this situation, and statements have been made that never ever a judgment may be based only on open source material. How dare you to base a judgment on newspaper reports? And that is a challenge that digital evidence, which is certainly a major piece of evidence in the future, will also be confronted with. But let's start in the courtroom in which I virtually sit here in courtroom 600 in Nuremberg and look at the Nuremberg principles. And principle 5 of the Nuremberg principles states the right of the accused to a fair trial. And that is something where one should not overlook the fact that, of course, and Paul Seal's videos just showed it a minute ago, do not only tell a story, but also are sometimes very, very emotional. And that has been proven always a difficult factor in the courtroom. So having now a protocol that takes away some of the ambiguities, that may allow to establish also technical standards, which are, from my point of view, essential when we talk about the credibility of these types of evidence. The ICC has issued an arrest warrant in the Libya situation, almost solely, if not completely solely, based on open source material, on digital evidence. The question is, how will this uphold in the trial proper, once hopefully a suspect is apprehended and has been surrendered to the court? All this is new ground. All these are a new phenomena which we embark now on, and the protocol is actually cannot be valued high enough as actually the first pioneering piece of fundament where many people can base their activities now on by asking what am I going to do? Am I pulling out my iPhone out of my pocket and start filming? Is that enough? Is that leading to a conviction? I'm afraid no, that's not going to be enough, and we all know that. And I think Kelly has mentioned that it is not only film, it needs to be corroborated by other evidence. It will be embedded by other evidence, but nobody knows at the moment by what kind of evidence and what the level of corroboration is that judges will require. So more work needs to be done next to promoting and promulgating and proposing the spread of the protocol and make it part of education and training so that people can base their activities on it. But we also need, of course, to overcome those difficulties. We do not want defense lawyers ruling out or asking for ruling out that evidence only because we have technical problems, and these problems will come. I just read the other day a very interesting article about deepfake videos, and it's amazing what's possibly technically possible in these days with this kind of technology, that it's at the fingertips, not only of the good guys, but also of the bad guys. And it is vital from my point of view that credibility of this evidence is maintained from the beginning. It would be devastating if in a couple of years people would say, yeah, you know what, this is coming from YouTube, we can't use that as evidence. So that is a task that remains for the future. We will see quite a variety of judgments, not only coming from international criminal or humanitarian law cases, but from serious fraud cases, from homicide cases, from other cases. And we need to make sure that all these can be found easily back, that the poor overworked prosecutor or the human rights defender who doesn't know where to start is not forced to spend days or weeks in libraries or over Google, but has a reliable access to the material, a one-stop shop, so to speak. And that is what the Academy intends to contribute. As I said, this is interdisciplinary work. It's not a plainly legal question. And it's not only a question of technology. It's a mix of all that. And we need actually to bring all forces together in order to explore these things further and to make sure that this kind of evidence is going to be established over the next years. The social media, in particular, open source material based on it, provide a unique opportunity. And it's very, very important that we all bundle our forces and work together in making the most out of it without giving up Nuremberg Principle 5, without coming to the idea, oh, it's on YouTube, it must be true. The Nuremberg films in 1945 and 46 had the huge advantage that at that time it was technically and also logistically impossible to fake such a film. There was no alternative to that being the truth. But today, we all know the situation is different, and that poses a challenge to which the Nuremberg Academy, with its research, tries to contribute a little bit in order to actually achieve what we all want to achieve, working in international criminal and humanitarian law. And that's ending impunity and give some dignity back to the victims. Thank you very much.
Thank you. And thank you for all the work that you and your team are doing to pull together these resources and create a place where we can all come to find more cases and more tools to actually figure out how we use this sort of material in case building. In closing, I'd like to just mention a little bit about the future. I think when we think about the future and what comes next, it's very hard to predict what will happen. I think there's no better illustration of that, honestly, than a global pandemic that none of us, or most of us, I should say, probably did not see coming when we were working on the protocol a year ago and thinking about its potential launch. But what the coronavirus has actually provided is a recognition of the urgency of thinking through how to conduct remote investigations, how to do them ethically and responsibly in ways that don't distort the truth, but help us get somewhere closer to it. And I think if there's any silver lining that I can see in this field of practice, it's the broadening of the methods, the training of new communities to pick up their cameras and to document what's happening when it is safe and when it is relatively safe and when it is ethical to do so, and to think through how we come together across disciplines, as Mr. Rockwitz just mentioned, to figure out how we create that future, ideally one that's really beholden to the rule of law. Even though we can't predict what comes next, I do think we have some sense of what's probable. In a world where 6,000 tweets are going out every second and 500 hours of video are going up on YouTube every minute, it's likely we'll face a future in which machine learning helps investigators and prosecutors deal with the scale and the scope and the speed of online information to better identify the digital materials that are relevant to our investigations and to the broader quest for justice. I think it will also be a future in which we continue to fight to ensure a balance between machine and human capabilities, idealizing neither, but ideally benefiting from the best of both, and one in which the sites of justice are positioned ever closer to the sites of atrocity, ultimately making sure that it's the stories and the interests of those who've been most impacted that are the driving force behind all that comes next. With that, I'd like to thank all of our panelists from panel 1 and from panel 2, and now pass the baton to Dr. Rainer Höhle, founder of the Nuremberg Human Rights Center, who will give our closing remarks from the city of Nuremberg. Thank you.
Thank you so much, Alexa, and thank you to all of you for these inspiring presentations and, of course, for launching this important protocol today. Let me start my brief concluding remarks taking up what Axel Fischer explained to us earlier. The Nazi atrocity films shown in Nuremberg are pictures taken and composed by the victors after the liberation of the camps. They could hardly illustrate the horrors in the camps with photographs taken before the liberation, for a simple reason. The Nazis had forbidden and tried to prevent by all means the photographic documentation of their crimes in the extermination camps. There is not one single picture preserved from the death camps of Sobibor, Belzec, and Treblinka. The Nazis did, however, take lots of photographs at Auschwitz, Mauthausen, and other concentration camps. Pictures under their control with the aim to convince their equals and themselves that there was civilized life there, that Auschwitz was a concentration camp, not an extermination camp. The most famous of these self-assuring documents is a so-called Auschwitz album, which was presented as evidence at the Frankfurt Auschwitz trial in 1963. After almost 3 decades of working in human rights education in Nuremberg, including many visits to this courtroom 600, I am convinced that such visual material is indeed key to keeping the memory alive, under the condition that we understand the limitations due to its origin and purpose. Now, among all the films and pictures around the death camps of the Nazis, there is one singular exception, and I want to mention it to you. In the Auschwitz Museum in Auschwitz, there are 4 tiny, diffuse, blurred square pictures preserved, taken in summer of 1944 by prisoners of a Todeskommando during the mass extermination of around 435,000 Hungarian Jews. These are the only photographs we know that document the Holocaust from a victim's perspective. While the prints have survived, the negatives are lost. The pictures were first published in the 1960s by Auschwitz survivor Hermann Langbein and the Polish survivor and co-founder of the Auschwitz Camp Museum, Kazimierz Smolin, and analyzed in detail by French historian and media expert Christian Delage. The camera for these pictures had been smuggled into the Birkenau camp by a member of the Polish resistance. It had to pass through several hands until the unknown photographer could secretly take the 4 shots. 2 of these shots show the workers of the Todeskommando collecting the corpses of the gassed victims for burning in open fosses. One shows hardly recognizable naked women driven towards the gas chamber, and the 4th, apparently taken furtively while the photographer was walking, shows only vegetation. The film roll was finally smuggled out from Auschwitz the same way it had been introduced. My question is, what drove the resistance members to take these photographs in conditions that seem impossible to do it? I think it was the belief that a photograph is the best and a necessary evidence, irrefutable in contrast to oral testimony. But are these unique 4 photographs taken by prisoners in Auschwitz the proof of the mass murder? Among the overwhelming evidence of how the Nazi genocide was executed, they are certainly not needed, and their chain of custody is even fragile. But what makes them so valuable today is that they give a powerful testimony to the courage and determination of the resistance, even in a place like Auschwitz. Also today, as Kelly Matheson reminded us, many human rights defenders place hope in the power of visuals. They collect and secure film material, often against great odds and despite significant personal risk. While the 4 little photographs from Auschwitz are rightly considered a treasure of testimony, we should remember that almost 20 years earlier, the German philosopher and journalist Siegfried Kracauer had already spoken in a pioneering essay of photography in the age of mass media as a demonic diva. Never before, he said, has an age been so informed about itself, if being informed means having a photographic image of objects. But he added, the flood of photographs sweeps away the dams of memory. The assault of this mass of images is so powerful that it threatens to destroy the awareness of crucial traits of reality. And his conclusion was, in the illustrated magazines, the social media of his time, people see the very world in the magazines prevent them from perceiving. It seems to me that the challenge of the task described so precisely and comprehensively in the Berkeley Protocol lies at some point between, on the one hand, establishing the value of an individual picture or a bit of film, recognize the often heroic gesture that made it possible, and transform it into a piece of evidence that testifies to a terrible truth. And on the other hand, taming the demonic diva, filtering the flood of images and information that threatens to engulf the precious piece of testimony. I'm not an expert on the many important technical and legal issues explained in the document, but just 3 years ago, when Syrian prison agent Caesar, remember he was mentioned by Kelly, was awarded the International Nuremberg Human Rights Award, we were confronted with the crucial importance of this sort of cruel evidence. And in my human rights work, I have been confronted with them again and again, especially in the context of forensic methods in the search for disappeared persons and in the investigation of this crime. So let me just pick the one aspect in this protocol that we all as human rights defenders will easily agree upon. All the intelligent solutions that the more than 100 pages of the protocol offer to investigators must be subject to the ethical principle of respect for human dignity, as was also highlighted by Michelle Bachelet at the beginning of this evening, even if that might affect, in a pure technical sense, the efficiency of the investigation. 75 years after the Nuremberg Tribunal, which was not really a model for respectful treatment of survivor witnesses, the respect for the dignity of victims of gross human rights violations should be a cornerstone of any criminal investigation in the digital era. I'm very happy that the protocol states in unmistakable terms that it aims to provide tools for conducting open source investigations, ensuring such ethical standards. And I hope that we all can live up to these standards when using digital devices to document human rights violations, and when putting the Berkeley Protocol to use in future efforts to advance accountability for international crimes. Thank you so much for your patience and attention. And now I return the floor to Katrin Kinzelbach for a very important announcement.
Well, first, thank you, Rainer Hule, for finding so powerful words to close today's event, or at least the formal part of the event, and for keeping us focused on what matters most, and that is human dignity. Now, this is the end of the formal part of the event, but as announced earlier, there will be an informal social hour, which of course may be even more important than all the formal contributions. It will happen after a short break. So if you want to toast on the launch of the Berkeley Protocol and celebrate this moment, then you're invited to get yourself a glass of champagne or juice, or maybe for those of you on the other side of the Atlantic, coffee might be more appropriate, but make sure to come back here in around 5 minutes. Stay connected to Zoom. We will reconvene right here in the same Zoom room. I know there has been conversations in the chat on the link to the protocol. I do believe it is being provided. I'm sure it will also be circulated widely on the website of Berkeley's Human Rights Center and of course of the High Commissioner's Office. On behalf of all the organizations that co-hosted this event, UC Berkeley's Human Rights Center, the UN Office of the High Commissioner for Human Rights, Witness, the International Nuremberg Principles Academy, the Memoriam Nuremberg Trials, and FAU Erlangen-Nuremberg, I thank you for joining us today, and do reconvene in 5 minutes for a celebration.